deal with qualified immunity. He does say something within it that's a little bit wrong. He considers in his statement that qualified immunity is an affirmative defense. It's not. Qualified immunity is an immunity. It's not absolute immunity. Immunity meaning you can't be prosecuted. Qualified immunity is when a particular person who works for the state has the ability to argue in front of the court that in the absence of proof that they, as long as they work for the state or are in the course of committing their state function, doing their state function, that they are immune from a particular level of prosecution as long as they can establish, or unless somebody can establish, that there was a precedent, that they violated someone's right, constitutional or otherwise, and they had a reason to know that they were violating this particular person's rights.
Can you give me an example?
The courts interpret that as there being case precedent that establishes that this is a right that the person has. So, for example, a cop shoots a kid dies. The parents sue. The cop has qualified immunity from that particular suit. It's not a criminal case. It's always in a civil case, always in civil litigation. And one of the real things is that what makes it immunity is that they grant you this immunity, but they say, would a reasonable person act in that circumstance? And the qualifier in that reasonable person standard is that there has to be some case precedent that would allow the officer to know that he is violating your rights. So, for example, Breonna Taylor was just killed by police officers in Louisville.
Right, unfortunately.
Breonna Taylor settled her case, or her family settled the case for somewhere in the neighborhood of $12 million. There never will be a case for somebody who gets shot like Breonna Taylor that establishes a case precedent. So therefore, the next person who sues, the cop may have sovereign immunity, or at least qualified immunity, because there is no case law out there that suggests that he knew or should have known, by virtue of his training and experience, that shooting someone in their hallway is illegal or violates their rights.
Okay.
Now, we know that as individuals. We can say as laypersons, come on, you shoot somebody, they're unarmed, you violated their rights. That's not how the law interprets it. It gives the police officer the benefit of the doubt and gives them immunity until there is a particular case precedent that establishes it. And that's why, I don't want to bust anybody's hustle, but that's why whenever we settle these particular cases without them going to trial, you don't have the opportunity to establish case precedent.
So them making that settlement eliminated case precedent.
The possibility of someone coming along after that and arguing, I have qualified immunity, because there is no case precedent that establishes that the conduct of a no-knock warrant, kicking the door and then firing on the people inside, there's no case precedent that establishes that. And that's what the hard part is in establishing these. If you can get past qualified immunity, then you go to affirmative defenses. So when Ice Cube puts in there that it's no longer treated as an affirmative defense, it's not. It's an immunity. Immunity meaning you can't be prosecuted for it unless these 1, 2, or 3 things are established. If you can establish that they knew there was case precedent, etc., then you can sue, and the person therefore would have to defend using whatever affirmative defenses that there are, like reasonableness, I was afraid for my life, etc., etc.
Right.